Yeah, but I mean, it's Dasia. Well, I mean, how do you pronounce your name?
Deja.
All right, I'm going to go with Deja, but I'm telling you all right now, I'm pronouncing it that way because that's how she says pronounce it. But there is no way you're getting a J from a Dasia. And then all of those vowels are not supposed to be talking. The only one that's supposed to be talking is the A and the I. Thank you. Thank you, Bianca.
That is Asia. We have to think about that way. So Asia, like Asia.
Well, then there should be a hyphen or either yes, thank you. A hyphen or either apostrophe. So it's Deja.
Asia. Asia.
You know what somebody told me forest is? How they spell forest? 4 F's, because it's forest, 4 F's. All right. I'm sorry. So Deja Garcia. All right. Are y'all ready to proceed?
Judge, do you have the court summary in that file?
Let me see what I have here. Is this the court summary that I really need to read?
No, Judge.
Okay. All right. Court is calling 2022 CR 2514 State versus Deja Garcia. Could I have parties announced?
Megan Galloway for the state.
Teresa Max Vasquez for the defense, Judge.
And are you Deja Garcia?
Yes, ma'am.
All right, Ms. Garcia, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Deja Rosette
Yes.
Garcia, who was placed on deferred adjudication in 2022 CR 2514 for the offense of attempting to take a weapon from an officer on May 26, 2022 for a period of 3 years? Is that you?
Yes.
All right, state.
Violation of condition number 41 on or about the 17th day of April 2025 in Bexar County, Texas. The defendant, Deja Rosette Garcia, did then and there fail to comply with the rules and regulations of the felony drug court by tampering with drug patch in violation of condition number 41.
How do you plead to that? True or not true?
Not true.
Okay. All right.
I guess I need to talk to the attorney because I thought something different was happening.
Okay. All right.
We could just step back for
Sure.
5 seconds. Just
All right. Thank you.
Judge, if I could, well, we're going to go back on the record.
Sure, we're
I'm
back
going
on
to
the record.
withdraw the condition of violation of condition number 41
Okay.
and proceed on violation of condition number 2 on or about the 31st day of March 2025 in Bexar County, Texas. The defendant, Deja Rosette Garcia, did then and there admit to consuming alcoholic beverages in violation of condition number 2.
How do you plead to that? True or not true?
True.
And then we waive and abandon the remainders, Your Honor.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 2, the court to find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There's not, Your Honor. The state is asking that you grant the state's motion, revoke the defendant's community supervision, adjudicate her guilty, and sentence her to 2 years in the state jail facility. She was placed on deferred adjudication back in May of 2022 and was a participant of felony drug court until this recent MTR where she was not in compliance with the program. And so that's why we're asking for the 2 years in the state jail facility.
All right. What are you requesting?
Yes, Judge, we are asking the court to consider the recommendation of the probation officer. We did confer with probation and their recommendation, as far as I understand it, is to reinstate her with the DDRF. It seems, as far as I understand, Judge, after talking to my client and reading the report, is that she did well on DDRF. She did not do well on safety, is what I understand. So I've had communications with her. I have an understanding, a little better understanding of DDRF and the difference, and she does feel that she benefited more with the dual. That includes the mental health
But
component.
didn't felony drug court have her on the dual track?
They moved her, that's a good question, Judge. I believe they moved her from the DDRF to straight safe P is what I understand. And that's where she
Didn't want to go to safety.
went astray, I believe.
So you didn't want to go to safety?
I just signed on it, cause just wasn't in the right state.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Deja Garcia.
So felony drug court, didn't they have you in their dual diagnosis program?
Yes, ma'am.
All right, so where are you saying you went off track?
I'm right a few months after I got out of DDRF, I got off track again, and that's when they decided to have me sign the safety.
Okay.
Because it was about after 4 or 5 months.
Did you go to safety?
Yes, ma'am.
All right, did you successfully complete it?
Yes.
All right, so then you get out of safety, then what happens?
I slipped up and I drank like on 2 of the violations.
So why did you drink?
Um, I think just because I was kind of overwhelmed when I got out of that facility. So I'm not trying to make it an excuse, but I was just overwhelmed.
All right, so to the court, and if I'm wrong, let me know. There seems that there's more than just this being overwhelmed, because I used to be an attorney in felony drug court. And when you're released from safety or some kind of inpatient treatment, they don't just let you fly free because they know you're going from a lockdown facility to coming out. So they really keep track of you until you're on the right path. Then they let you be freer with your time. So I'm not understanding. So you leave safety and you start drinking.
Yeah, ma'am. A few weeks after I get out, I drank like once or twice.
Mhm.
I just had a lot of
Can I say something, Judge?
Sure.
Okay. So I spent a little time with her, and I don't know if maybe she's not remembering, or the communications we had, we went over the excuses and how just give them the facts and tell them what happened. What I see in this is, I asked her, how did it happen? What happened? What was your plan? What was the goal? How did it work after you got off? You got out just like you just went through with her. What she hasn't said was that she tried to enroll in school. She moved back home, I believe, correct, with your parents. And so that's where we stopped. I think it was a few months ago.
Well, here's the thing. When you move back in with your parents, the felony drug court approved you moving back in with your parents?
no, ma'am.
All right. See, that's part of the problem, because felony drug court has rules where you can stay, what you can be doing. When she got out of inpatient treatment at Safety has an aftercare program, which is what she's supposed to be in, and felony drug court would still keep track of her. So this thing right now, what she's doing, she's not being 100% honest with me. It sounds as though she didn't want to do safety, but they made her do safety. Then she's released from safety and she's in aftercare and she don't want to do that. So she starts doing her own thing. Felony drug court has a dual diagnosis program.
Mhm.
And if she had mental health issues that were happening, they would address those. But if it's somebody who wants to do whatever they want to do, drug court is just not going to let you do whatever you want to do.
Correct. And that's why we are asking the court to consider what the probation office has recommended, which was to put her back in the DDR program, Judge, because I agree. I mean, I think she did better in that treatment program versus what we're talking about here on the safety and handing it over to her. She wants that. She wants that reinforcement of the
But she
mental
was
health
doing
component.
But here's the thing, DDRF is in inpatient treatment.
She understands that.
I don't think she's a good candidate for probation. I mean, I don't think she's a good candidate. Felony drug court is a very good program.
Yeah.
If you follow the rules, but sometimes people don't want to follow the rules. I don't think she's a good candidate for probation.
I believe this was only her as far as I know, Judge, from what I can speak to is the report, this was the only violation that we have on her, and it was right after Safe P.
But see, here's the thing about that. Felony drug court, when people come back to this court from felony drug court, yeah, that's the only violation they have because felony drug court is sending them back. But when you're in felony drug court, they don't automatically kick people out of the program. They go through different steps, graduated sanctions. So they have technically, probably in felony drug court, she could have probably had 10 motions to revoke by now, but they don't do that. And I'm sure there's a reason why they did not approve her living with her parents. And part of that reason is because of the drinking. And they knew that they had probably already tried that before with her living at home, and they told her no, but she wanted to do what she wanted to do. So now we're here, and I don't think she's a good candidate for probation.
I just feel, Judge, that the element of putting her straight into the state jail felony detention center, it just squashes the whole program of rehabilitation. I think she agrees. If it's going to mean more time, Judge, I think that the benefit would be there for her to do the mental health component. She clearly knows that she needs that help, as far as I know, and she's being fully, as far as I know,
Yeah.
you know.
But felony drug court was giving her that. She didn't want it. She wanted to do her own thing. And I don't think she's a good candidate.
Okay, I understand.
All right. The court is going to grant the motion, find you guilty, revoke. Now, the next question is, you're asking for 2 years?
Yes, Judge.
All right. And state, why are you asking for 2 years?
Judge, she was in the felony drug court program. They did do graduated sanctions with her. That included the DGRF and Safe P. And she just still could not comply with the terms of probation. So that's why we're asking for what we're asking.
All right. And what are you requesting?
Credit for time served. I believe she's already been there a little over 12 months. Doing the program, Judge, that's already 12 months that she's been in custody, I believe.
All right. The court will sentence you to 2 years in the state jail facility, give you credit for any time served, and not give her credit for any successful inpatient treatment. If she successfully completed DDRF, then she'll receive credit for that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you when you're released from custody. If you're still trying to find help with your mental health or maintaining your sobriety, if I'm still here, you come back here, I'll pick up the phone and call for a placement for you. All right, good luck to you. Court is calling 2024 CR 4900 State versus Damian Trevino. Can I have parties announced?
Megan Galloway for the state.
Teresa Max Vasquez for the defense.
And are you Damian Trevino?
Yes, Your Honor.
All right, you need to speak up so I can hear, all right?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, Your Honor.
Did you understand it?
Yes.
Are you the same Damian Isaiah Trevino who's placed on deferred adjudication 2024 CR 4900 for the offense of burglary of a building on June 10th, 2024 for a term of 4 years? Is that you? Is that you?
Yes, Your Honor.
All right, state.
Judge, do you have the court summary up there again?
Yes.
Violation of condition number 28 on or about the 24th day of January 2025 in Brazoria County, Texas. The defendant, Damian Isaiah Trevino, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant was unsuccessfully discharged from the Stringfellow Safe P unit in Rosharon, Texas, in violation of condition number 28.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of number 28, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 28?
Yes.
Court will find violation of condition number 28 true. Is there a proposed agreement?
No, Judge. The state is asking that you grant the state's motion, revoke the defendant's, or adjudicate the defendant guilty, revoke his community supervision, and sentence him to 2 years in the state jail. This is his second MTR. He was placed on deferred adjudication by the court on June 10th of 2024. He was ordered to go to safety, and during his time there, he did receive multiple offense reports, including testing positive for K2. And so we are requesting that you sentence him.
Testing for positive at safety. Inquiring minds want to know. All right. Yes. Counsel, what are you requesting?
Yes, Judge, after talking to my client and going through his options, we are asking the court to consider the time that he has been there as satisfied, and he's been in custody for 15 months, I believe. Yeah. About a year, Judge, working, as they just mentioned, working that program unsuccessfully. And request that the court, his original offer included 1 year, Judge. He did not take that off.
Oh, no. Here's the thing. I'm not allowed to hear about what your previous plea bargain negotiations.
Understood.
Those confidential.
Understood. He chose an option that gave him more time, and we would like the court to consider that 1 year might be considered satisfactory for the situation that we're in today, and if the court would take that into consideration as serving the time that he's already been in custody.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Damien Isaiah Trevino.
All right, what did you successfully complete on probation?
I went to lifetime recovery. I was doing AA meetings at lifetime recovery.
Why are you doing drugs at safety?
Fed into the wrong crowd. Got offered it. Thought I wasn't.
People always think they're not going to get in trouble. If you just follow the rules, you'll do good things. Did he successfully complete lifetime recovery?
Yes.
And he also did take responsibility for the transgression in safety, Judge.
It's not on the court summary. If you just give me 1 moment, I can
Okay.
look at his file.
All righty. Yes.
Yes, Judge.
All right. Is there anything else?
I think it,
No, I was going to parenting class.
Did you complete it?
All right.
No. All right, the court is going to find you guilty, revoke. The court will sentence you to 23 months in the state jail facility. Give you credit for any time served, and the court will request a therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand that?
Yes, sir.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you want deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, since he didn't successfully complete inpatient treatment time, he's not entitled to that time. All right, when you're released from custody, if you can't find a place to help with your sobriety, you come back here. I'm still here. I'll pick up the phone and call some place to help you. All right, good luck to you. You're welcome.
do we have, I'll get you a copy of the,
You didn't sign both of them. You only signed one. If you would like for
Yes,
them, they
Judge.
can make you a copy.
okay,
Just give me a moment.
yes.
All right. Court is calling. Are there any applications?
Yes, Your Honor, they should be attached with the paperwork.
All right. Court is calling 2025 CR 0092, 2025 CR 0000071, 2025 CR 0000069, State versus Xavier Chamberlain. Can I have parties announced?
Rick Pena for the state of Texas.
Renee Munoz on behalf of Mr. Xavier Chamberlain.
And are you Mr. Chamberlain?
Yes, Your Honor.
Counsel, have you received all discovery in each of these cause numbers and did you review it with your client?
Yes, that's the both questions, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and did you sign it?
Sure.
In each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
That's right.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State and the cause number ended in 9-2. Are you proceeding on the indictment as presented?
No, Your Honor, we will waive the habitual offender enhancement.
Objection.
And in cause number ended in 7-1, are you proceeding on the indictment as presented?
No, Your Honor, with that case, we'll waive the habitual offender enhancement as well.
No objection.
And in cause number ended in 6-9, are you proceeding on the indictment as presented?
No, Your Honor, with that case as well, we will waive the habitual offender enhancement.
No objection.
And each cause number, did you review the court's admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
And the cause number ending in 9-2, you're charged with violation of bond protective order 2 times or more within a 12-month period. And the cause number ending in 7-1 and 6-9, you're charged with assault family household member with a previous conviction. All of those are third-degree felonies with a range of punishment anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow the plea. If for any reason the court does not follow the plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each case, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering into these pleas, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
In each of the cause numbers, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Your Honor.
Mr. Chamberlain, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application. The cause numbers will run concurrently. The state will take in consideration 2025 CR 0000070, 2025 AL 002118. There's an affirmative finding of family violence, and the cause numbers ending in 7-1 and 6-9. And then in each cause number, there is to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then in the cause number ended in 9-2, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ended in 7-1, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And the cause number ending in 6-9, how do you plead? Guilty, not guilty, or no contest?
Contest, Your Honor.
state any evidence to support the defendants, please?
Yes, Your Honor, with regard to all three cases, state will offer into evidence per each case, states Exhibit 1 with all attachments.
No objection as to each of the exhibits.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, thank you. You may be excused.
Thank you, Your Honor.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each case number, the court will find that there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, it's 6 to 8 weeks for a PSI, or if you would like, I could set it sooner and you can present whatever witnesses you wish to present to the court.
I went over those options with my client and talked to him about the potential timeline regarding a PSI. We're respectfully requesting PSI, Judge, and also if it could be made a part of the PSI, a TAP and mental health evaluation, as my client has some issues that I think a PSI would be helpful for the court. In this instance, at least have some background regarding that.
All right, then we'll schedule for a PSI, TAP evaluation and MIC evaluation. What date, please? All right, July 15th.
I have that date down, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right,
Have a
thank
good
you. You too.